the release on bail of journalist Prashant Kanodia, who was arrested by the UP police for tweeting offensive videos. One of the videos showed a woman making allegations against UP Chief Minister Yogi Adityanath. Two other journalists have also been detained for similar social media posts. Now, this is not the first time an over-enthusiastic state police has moved to detain citizens whose social media comments have hurt fragile egos of their political bosses. Right before the Lok Sabha elections, a BJP worker called Priyanka Sharma was arrested by the West Bengal police for retweeting a meme that mocked Chief Minister Mamata Banerjee. In fact, there are numerous cases where laws have been invoked to clamp down on citizens by governments of all political hue. So how can ordinary citizens make sure their freedom of expression is protected? But the deeper debate also is, how can a balance be maintained between the right to say what you think and making offensive statements that can truly disturb law and order? To speak more on this, I am joined this evening by Justice Ashok Kumar Ganguly, former judge of the Supreme Court of India, Akriti Bopanna, Policy Officer at the Centre for Internet Society, and Ameen Jauhar, Senior Resident Fellow at Vidhi Centre for Legal Policy. Welcome to all of you, and thank you for speaking with us today. Justice Ganguly, I want to start with your view on what we have seen, not only in the case against Mr. Kanodia. There are others who are also, been arrested, and the way that the Supreme Court, in its order, was clear to point out that this was a punishment which was more in the current context of what this man was charged for.
Yes, look here, the question of freedom of expression,
yes,
before considering the contours of this right, you must understand that we are living in a republic and we have a written constitution with a Bill of Rights and an independent judiciary dealing with all these rights in a case of a conflict. Now, freedom of expression is a cherished, protected fundamental right, and this right has been protected under our constitution after a long fight. This is one of the cherished ideals of our freedom struggle. Now, in an independent India, we find that this right is invaded at the instance of those who are in power.
We are losing your feed and I cannot hear you clearly, which is the only reason I'm cutting you off. I'm going to ask them to fix it and then come back to you so we can hear clearly what you are trying to say. I want to move on meanwhile to Akriti Bopanna and come to the basic question that we have seen today. The entire debate around Mr. Kanodia and the others who were arrested, and rightly so, have centered on the high-handedness of the Uttar Pradesh police. It has also become fairly political, considering it is a BJP-ruled state and the Chief Minister is a controversial man. But isn't it a fact that government after government has misused current laws to clamp down on people, especially with the advent of social media?
What happens is that especially, we're seeing this off late, is that the charges that happen, that are now put on the people that are being arrested, have not much nexus to the act themselves that are carried out, and a lot of these charges are politically motivated. So even what happened with Mr. Kanodia, initially when he was charged, there were sections of, there was section 500, there was section 66, and section 66 deals with fraudulent tampering of a computer. So these charges didn't even have any relation to the act that he carried out. So not only is it alarming, as you said, the high-handedness of the government, but also the brazen manner in which they sort of go about putting charges that are discernibly not related to the act themselves, sort of shows the kind of confidence or sort of indifference that they have to following the letter of the law itself.
Okay, no, that's fine. So clearly the charges were such, and let me get in Ameen Jauhar here. The charges were such that they wouldn't stand scrutiny in a court of law. But the fact is that this man was a journalist. And there was a huge uproar about his arrest, which led to the Supreme Court looking at it in such a hurry. There have been other cases. There's been a journalist who has languished for weeks under the National Security Act. On charges of putting something out on a Facebook post. They might be common citizens who might put something out and might not be well connected. So the question then becomes about how does one protect oneself if you want to express and enjoy your right for freedom of expression?
Tamanna, I think I would just start by saying that one, I think this particular course on freedom of expression being violated and used for political ends as a discourse has run its time, and I think it's time to find a proper remedy, be it legislative or through jurisprudence, that needs to put this beast to rest. That said, I think again today's example and the order that's coming out of the Supreme Court today afternoon is again showing us three main issues that are here. One is the broad violation of certain tenets and principles that have been laid out in case law after case law by the Supreme Court, by the High Courts and the judiciary, safeguarding the principles and the fundamental right of free speech. The second is the arbitrariness with which provisions are used, under the penal provisions are used, something that Akriti is also referred to, like completely unrelated, baseless charges under 66, which is a hacking of a computer. Hacking can be something that is only done by an outsider by definition, and yet you are arresting the person who himself has made those posts. So these are baseless, arbitrary claims. And the last is, if you are to resolve this, can it only happen through judicial verdicts and decisions, or is it time, like Justice Ganguly also mentioned, that we need to think of a broader legislative framework to bring this menace to an end? And I think on the question of free speech and freedom of expression, the law is quite clear. When it comes to a political office, this was something that the Supreme Court has laid down unequivocally in Jayalalitha's case in 2016, where they said that being part of such a political office, you have to bear with the criticism, which is fair and sometimes can be a little unfair. But that is part of your
let
job.
me come in 1 minute. I get your point. You know, my question was more specific. We know that the slapping of the cases is wrong. Time and again, the courts have come and bailed out people who are unfairly charged, at least in those cases which get media attention. What about everyone else? What about the fact that by the time you get to court, it may take time? In this current case, the Supreme Court points out that, you know, if they hadn't stepped in when they did, the man would be languishing in jail for 13 to 14 days for a tweet. So my question is, what can common citizens then do?
I think, again, I would point out to the fact that you earlier raised the point of how do we protect ourselves against such arbitrariness. See, the protection is fundamentally enshrined in the language of the Constitution. There is no debate on it. The problem happens when police officers or politicians are arbitrarily imposing ideas and creating offenses, conjuring offenses which do not simply exist. And the only way to actually protect the common man from this is, again, like case law by case law, the judgments have evolved principles. But I think I will finally say that there has to be a legislative framework which deals with this complication, this conundrum more definitively and in a long-term sense. And that, like, to some extent, I can give the example. There was this bill that was tabled by BJD MP Tathagat Satagahi in 2016, which talks about the balance between protecting someone's reputation versus civil defamation suits. Now, this was a legislative attempt to sort of, crystallize the position on the law and at the same time allow some remedies for somebody who genuinely feels aggrieved. But see, this is the kind of situation that requires more legislative frameworks to be explored, because Supreme Court is going to only pass judgments one at a time.
So here's the problem. Let me get Akriti into this. Here's the problem. You're saying there should be a law that parliamentarians effectively have to make. Well, they're the guys who have the thinnest skins and don't like anything being said about them. You're coming back to the same class, expecting them to make laws to make it easier. Now, let me present the counter to you as well, Akriti. The fact is, right now, we're also dealing with a huge fake news menace. where videos go viral and lead to violence in different parts of the country. Lives are lost, and you expect the same police and administration to crack down on people who are circulating these fake videos. So where do you draw the line then?
Right. See, but I mean, what you're talking about also, though, in my mind, not as much conflated of an issue, because when you're talking especially about criminal defamation, and as Ameen mentioned himself, we have certain protections enshrined by the Constitution, and there is certain procedure to go about it. So even if you look at Section 500, for example, the very basic fact that defamation, the suit has to be filed by the complainant themselves. So which in this case didn't happen, right? With Kanojia, I mean, the CM didn't come and file a complaint. So to that effect, even the laws we do have, if they're not followed by sort of the procedure that are that's mentioned in the laws that we already have, then to tackle new problems like fake news is going to be much more difficult. I mean, we're not dealing with the existing framework itself very well. So how do you deal with fake news and things like that, which are also problems of technology that we're seeing now when we're trying to deal with using the IT Act and all the other sort of legislative provisions that we have. But it's I mean, in my mind, it would be first to sort of the problems that we do have offline to be carried out in a manner that's transparent and that's going by the letter of the law, and then to sort of see that the new problems that are arising out of technology, how those can be better dealt with, whether it's legislatively or whether to judicial
Akriti, you're splitting them into old,
make that distinction between,
Yeah, you're splitting them into old and new, but they're all happening simultaneously, right, at the same time. I've got Justice Ganguly on the phone line with me. Justice Ganguly, we've been asking two fundamental questions here. One is that in a lot of these cases, and not just with the Uttar Pradesh government, which really had to face extreme embarrassment when the Supreme Court called out the arbitrary use, of law to harass or muzzle someone's freedom of expression. Various governments have done it. These cases go to courts, and then there is trial, and then the courts step in, especially in cases which are high profile, and the media comes in and does its bit, or social media comes in and does its bit. What about everyone else? How can citizens protect their own rights to say what they want to without breaking the law using social media?
Listen, unless the cases come before court can't intervene. So if it is the freedom of expression of an individual who is not a journalist is affected, he has to bring it to the notice of the court. Unless the matter is brought to the notice of the court, the government excesses cannot be corrected. And you are talking, as I heard, that there are cases when something is going on the social media, becoming viral, causing a lot of tension, and sometimes leading to loss of life. I think these can be tackled under the heading of public order. Public order cannot be disrupted by your freedom of expression. This is a well-known exception to your fundamental right. So if public order is disrupted by your freedom of expression, then you are abusing your freedom. I have told at the very beginning, the freedom of expression is not an absolute right. It's a relative right. It is conditioned by certain exceptions. And one of the exceptions is maintenance of public order. If I disrupt public order by making a speech which is highly inflammatory, then government has a right to take steps against me, because that is permissible within the Constitution. But if I attack somebody just personally, or if I just crack a joke, and then I cannot be arrested.
But how will you make the distinction?
Understand the distinction. You see, here, what has happened in West Bengal Chief Minister's case?
Yeah.
A professor circulated a cartoon on a storyline based on the film meant for children by Satyajit Ray. It's an innocent thing. Even then he was arrested. This has nothing to do with public order. This has nothing to do with decency. This has nothing to do with morality. Nothing to do with the integrity or security of state. Even then the gentleman was put under the bar. This is sheer excessive power of by executive authority. These are the cases where the court gives its verdict correcting the excesses. So you must understand when you are exercising your coercive power, the state must understand the parameters laid down clearly by the Constitution. As I've told you, there are 8 parameters.
Yes.
You cannot, please listen, You cannot exercise your freedom of expression in such a manner which will affect the sovereignty and integrity of India, the security of the country, the public order, decency, morality, contempt of court, nor can you incite an offense by your freedom of speech. These are the well-known parameters laid down by Supreme Court, by the Constitution. That the government should follow and understand this. The government by assuming its power cannot just reverse the Constitution and fundamentals. You see, government will come and go. The BJP government today is here, tomorrow it may not be there. But these principles must be there, must be followed.
Yes.
When they are not followed, the court intervenes.
Justice Ganguly, may I just ask you, you made a very fine point about, the balance between abuse of your power as a government machinery and where you need to step in to make sure that there is no incitement of violence, etc. But that discretion then lies with the police official who's executing that order. And by the time the citizen makes it to a court to fight for his rights, it may be an inordinate amount of time in most cases. Should there be, in your view, some kind of legislation which would curtail the instinct that politicians have of really cracking down heavily on people who say things that they don't like to hear?
Yes, if the citizen infringes these restrictions on his freedom, the government is there to take steps. Government can take steps, and in those cases, the courts will not interfere. I'm more than sure.
Absolutely. I want to thank you so much, Justice Ganguly. Yes. I want to thank you so much, Justice Ganguly, of course, Ameen Jauhar, as well as Akriti Bopanna for joining us on the show today. It's a very important debate about what constitutes the freedom of expression and what crosses the line, which is why before we end the show today, I'm going to tell you about the case of one Birju Sala as an example of what definitely crosses the line. He has become the first person to be booked under the Anti-Hijacking Act. You may remember a story from a few months ago of a man who wrote on a tissue paper box in an aircraft claiming that there was a hijack scare. He did it for a personal reason. He was jilted in love and he wanted his girlfriend back. Well, he has today been sentenced to life imprisonment by an NIA court for that hijack scare. He also has to pay a 5 crore rupee fine. So there is a line. There is definitely a line. It's for each one of us as citizens to know when it's being crossed, and definitely it's up to governments to know when to not abuse their power. On that note, I thank you all for watching the India Development Debate.